Setting up a factory in India involves more legal groundwork than most people expect. Miss the wrong step early, and it can cost years and crores to fix later. Legal due diligence is how companies find those risks before they become problems. In 2026, skipping this step is one of the most expensive decisions a company can make.
The regulatory environment for industrial projects in India has tightened sharply over the last 5 years. More laws, more approvals, stricter courts, and more ways for a project to get stopped after it has already started. Legal due diligence is what maps all these steps before the first rupee is committed. When done properly, it costs between 0.5% and 1.5% of the total project value. That small investment routinely prevents losses of 10 to 50% of the project cost from problems that surface after signing.
The biggest risk in any Indian industrial project is the land itself. Land title problems are the most common reason projects get derailed in India, and they are almost always preventable.
The standard check is a 30-year title trace through registered documents. That means going through every sale, gift, inheritance, and court order on the property over the last 3 decades. It also means cross checking those records against Revenue Department files to make sure ownership is consistent across both sets of documents. What this process regularly uncovers includes unresolved inheritance disputes, land split across multiple family members, unpaid loans secured against the land, and records in the Revenue Office that do not match the registration office. A title that looks clean on the sale deed often unravels when these two sets of records are compared side by side.
Beyond title, the land also needs to be legally usable for what is planned. Clean ownership of land that cannot be used for a factory is not actually an asset.
Industrial use requires conversion from agricultural to non agricultural land in most Indian states. This conversion has to be completed, not just applied for. The master plan for the area also needs to permit the type of factory planned. Some zones allow light industry, others allow heavy or hazardous industry, and others do not allow any industrial activity at all. Local body approvals, panchayat permissions, and urban planning clearances add further steps that get missed when diligence is done in a hurry.
After land, the second most consequential area is environmental clearance. Getting this wrong can shut a project down after it is already built.
India's environmental impact assessment rules require prior clearance for over 40 categories of industrial projects. Prior means before construction starts, not before operations. In 2025, the Supreme Court of India reaffirmed this in a landmark ruling. It confirmed that a project started without clearance cannot be fixed later. This means starting construction before getting clearance always carries a legal risk that can never be removed.
Environmental clearance is also the longest item on the approval timeline. For large projects, the process runs between 12 and 24 months. That timeline has to be built into the project plan from day one.
Beyond environmental clearance, projects also need a consent to establish from the State Pollution Control Board before construction begins. Then a separate consent to operate before production begins. Hazardous waste authorization, groundwater permits, and forest clearance apply in many cases as well. Each approval has its own timeline, its own documentation, and its own risk of being delayed or refused. Mapping all of them before the project is committed is what separates a realistic schedule from one that will slip.
There are four mistakes that account for most of the legal problems industrial projects face in India. Each one is avoidable.
The first is compressing the diligence timeline under deal pressure. A structured legal review takes 6 to 12 weeks. Cutting it to 2 or 3 weeks to close faster almost always leaves material issues undiscovered. Those issues surface 12 to 24 months later with remedy costs far higher than the time saved at the start.
The second involves brownfield acquisitions, which is when a company buys an existing plant or takes over a running operation.
When a company acquires an existing business, it can inherit everything that the previous owners left unresolved. Pending tax demands, environmental violations, unpaid worker dues, and ongoing court cases can all transfer to the buyer. The only way to know what is transferred is to review the business's full compliance history. This is different from a greenfield check, which looks forward at what is needed. Both need to be done, but mixing up which approach applies to which project is one of the most common and costly errors in industrial due diligence.
The third and fourth mistakes are about how the diligence is organized.
Another common failure is running legal, tax, environmental, and technical checks as separate work streams that never talk to each other. Some issues cross multiple areas. Contaminated land, for example, is both an environmental problem and a tax liability. These issues fall through the gaps. This is followed by the last mistake, treating the diligence report as the finish line. Listing problems isn't enough. Without ranking them and linking them to fixes, the real risk management work still isn't done.
Legal due diligence done well offers one of the highest return on investments in any industrial project. It identifies the right land, confirms the right approvals are obtainable, and surfaces the risks before capital is locked in. If your company is evaluating land in India or acquiring an existing facility, IMARC Engineering provides end-to-end legal and regulatory due diligence for industrial projects. Reach out to discuss your project before the first commitment is made.